gotta stay out of my head. Stuck between my rights and my wrongs. Second guessing what I'm doing. Like, am I really there for my boy? Not enough, but if I'm paying child support, do they make it for time that I've lost? Whole time paying this court system. Can't even call my little man a game system, cause my checks be short. And if your bag too short, well, you had to miss a month. Slipping up, I gotta pick it up. Grind limitless, but it got your folks like, yeah, I hope you don't get caught. Like I missed them payments on purpose. Cause you see I fail and I'm hurting. Ain't had no job, so no working. Or the job I work is not working.
Shalom, this is your ARC. Y'all is magnified. Coming back with another informative video. I titled this video, James Frederick Williams, 42, U.S.C, 1983, Federal Lawsuit, Part 2. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, let's get to it. Okay, so as you all know, I did part 1 a day or so ago. If you all haven't watched part 1, then pause this video right now. Click on the link in the description box. It will take you to part 1, okay? It's mandatory that you watch part 1 first before you watch part 2, okay? Because in part 1 was James Frederick Williams' original complaint that he filed into the court against the defendants, okay? So now we're going over 2 of the defendants' motion to dismiss. Then we're going to go over the remaining defendants' motion to dismiss in another video, okay? So now, excuse me, guys. So now, as you all can see on the screen, let's pick this up at the top. It states, in the United States District Court for the Eastern District of Tennessee, Chattanooga Division, okay? We know that the original complaint was filed in Tennessee. So why are they now in Chattanooga? They're in Chattanooga because Tennessee lacked venue. Once they lacked venue, they had to transfer the venue to Chattanooga, okay? Where it's supposed to be found in the beginning. So now, as you all can see, the plaintiff is the same. The defendants are the same. Let's pick this up at the top. Okay, it states, defendants, Maximus Inc. and Stilsey Elrod's memorandum of law in support of motion to dismiss. 1. Introduction. Plaintiff, pro se complaint, attempts to bring a Section 1983 action against all parties involved in his child support proceeding before the Hamilton County Juvenile Court, Child Support Division, Juvenile Court, over the span of the last 2 decades. The complaint, without stating any facts, concludes that the defendants violated a litany of plaintiff's constitutional rights without due process. Docket number 1. That's why I say it's mandatory to go back and watch video number 1, because they're now going over the docket number 1, which was what? James Frederick Williams' original complaint. But let's continue. Plaintiff cannot prevail on any of his claims for the following reasons. 1. The court lacks subject matter jurisdiction as to the defendants Maximus and Elrod. 2. The allegations raised by the plaintiff are merely conclusionary and not actionable. 3. The plaintiff fraud claim is not pled with particularity. And 4. The defendants are entitled to qualified immunity. As such, the court should dismiss the plaintiff's complaint for the reasons outlined below. 2. Summary of the facts. It states plaintiff has been subject to child support payments since 2000 or earlier. Defendant Maximus contracts with the Tennessee Department of Human Services Child Support Division, TDHS, to provide certain child support services, including managing child support payments and wage garnishments in Hamilton County, Tennessee. Defendant Elrod is an employee of Maximus, where she works as a legal administrative specialist. As part of her employment at Maximus, Elrod is the case manager for plaintiff files. Let's continue. On April 18, 2000, the juvenile court entered a default judgment against plaintiff for current child support in the amount of $382 per month and back child support in the amount of $50,829. Case law to support that. Then it states, with the case number, then it states, Hamilton County Juvenile Court, April 18, 2000, the order. Then it states, defendant Maximus is responsible for enforcing the order and collecting the child support payments from plaintiff as part of its contractual obligation with TDHS. Defendant Elrod is responsible for what? For processing the wage garnishments issued against the plaintiff. So again, guys, what we just read, We just read that they admitted to being in a contract. Like I told you, it's not about them abandoning the contract. The whole thing is getting them to prove that they waived sovereign immunity, or that the legislator waived sovereign immunity to sue these people in federal court, which they didn't do. Okay, so him going into courts arguing contracts, they already know this already. It's their contracts. They the ones that enter them. They the ones put them in the public for all to see. Why? That's all public information. So there's no need to go in there arguing that. But let's continue. Legal analysis. The plaintiff's complaint, without offering any facts, concludes that the defendant fraudulently executed withholding orders to garnish his wages, and that they acted in a manner that violated his constitutional and statutory rights. Docket number 1. The fact is the plaintiff case is based on a child support grievance, a domestic relations matter that the plaintiff is now attempting to seek relief from by claiming that all persons and institutions responsible for. Okay, page 2. Let's go to page 3. Enforcing a valid child support order and judgment against him violated his constitutional rights. The plaintiff's allegation fails to state a claim upon which relief can be granted and should be dismissed as a matter of law. A. This court does not have subject matter jurisdiction over plaintiff's claims. Federal courts are courts of limited jurisdiction and may only adjudicate cases that are authorized by either the Constitution or by the Congress of the United States, which is true, guys. Remember, I told you the legislator must what? Must waive the immunity of the state. The legislator or Congress did not enter into Congress stating that the states may be sued in federal court for what? Domestic relations issues. So that right there prove that the court lacks subject matter jurisdiction. But the person having you all go to these federal courts to try to make you all believe something totally different, which is far from the truth. You know, like I said, but a scam artist is going to be a scam artist. And I'll keep trying to show y'all this truth for you all get better understanding of what's going on before filing into these federal courts, making a fool out yourself. But let's continue. The party invoking the court's jurisdiction has the burden of establishing the existence of a federal jurisdiction, which is true. Let's continue. The plaintiff's complaint does not include any facts which support this court's jurisdiction over this matter, either as an arbitrary claim or based upon the appropriate subject matter jurisdictional standards. As such, the complaint should be dismissed, which is true. But let's continue. I. The plaintiff claim is solely based on a domestic relations matter, not a colorable claim under subsection 1331, capable of establishing federal question jurisdiction and should be dismissed. Federal question jurisdiction requires a plaintiff to plead a colorable claim arising under the United States Constitution or federal statute, 28 U.S.C. subsection 1331. A plaintiff is prohibited from simply referencing a federal statute or constitutional provision in order to invoke the limited jurisdiction of a federal court. Case law to support that. Even a pro se plaintiff is required to meet this minimum requirement as set forth in Rule 8A, which requires that a pleading contains a short and plain statement on the grounds upon which the court's jurisdiction depends. Again, so he haven't stated or proved that the court has jurisdiction. He haven't proven that the legislator waived the state's sovereign immunity. That's what he haven't done. But let's continue. Plaintiff's complaint does not contain any statement which explains how this court has subject matter jurisdiction over his alleged claims. The fact that the plaintiff is proceeding, we're on page 3. Let's continue. Pro se does not excuse him from complying with the basic pleading requirements. Case law to support that. Then it states litigants are not exempt from requirements of the federal rules of civil procedures. That's why I tell you all learn the rules of civil procedures, but don't learn just federal rules of civil procedures. Learn your state rules of civil procedures, because that's what you need to take your fight to in the state court. But let's continue. In general, federal courts do not have jurisdiction over domestic relation matters. I told you all that, right? And the case law to support that. You see how you have case law supporting everything that they're saying? They're using what? Legal authority to support everything that they're saying. But let's continue. Rather, state courts have exclusive jurisdiction over these matters. When I tell y'all, who have jurisdiction over these matters? State courts. So why does the fraud law keep telling his clients to go to federal court? It bewilders me, man. Let me know that either this guy is truly an agent or this guy is a complete scam artist. He's even one of the two. But he's trying to tell everybody, to have everybody to believe that I'm an agent. No, I'm not the agent. I'm the one showing case law and everything else to rebut his presumptions, what he believed to be true, which they are all false. But let's continue. It states that The fact that a domestic relation case is brought under the pretense of a federal question does not alter this rule, which is true. Holding that the district court properly held that it lacked jurisdiction over plaintiff claims when a fair reading of plaintiff's complaint revealed that it was a pretense to obtain federal review of a domestic relations matter. That's what it is. He wanted to review a domestic relations issue such as child support in federal court to try to have federal court overturn a state court ruling, what they cannot do. For the simple fact of the matter is, the federal court does not have subject matter jurisdiction to even hear this matter in federal court. But let's continue. In this case, the plaintiff filed suit against every party that has been involved, even in limited capacity, in his child support proceeding before the juvenile court. The plaintiff would have this court believe that his complaint is not about a domestic relations matter when he stated that this is not a complaint about a judgment or decree for financial support for his offspring. Now, in the first video, I went over that same sentence. Why? Because it clearly states that his whole argument is about his offspring and him paying support, but he's trying to make it seem though it's not. But let's continue. This is not a complaint about a judgment or decree for financial support for his offspring. However, in his prayers for relief, the plaintiff's first request is that this court enter a judgment in Williams' favor to terminate 4D collection cases with the case number and alleged arrears effective immediately. Again, will further prove that this is a case about what? Child support payments. So this is a domestic relations issue. The only thing I'm doing now is letting you all see the responses so you all can see why people are losing in these federal courts and why I'm telling you all to stay out of these federal courts. But let's continue. The plaintiff's prayers for relief further included a request for reimbursement of $26,641.04 as part of child support payment he previously made, as well as removal of any and all negative reporting to all credit bureaus. Document number 1 at 16. What we just read yesterday, but let's continue. A plain reading of plaintiff's complaints clearly demonstrate that his allegations are based on a domestic relations matter and that plaintiff is using the complaint as a pretext to, we're on page 4. But like I told you all, this is clearly a domestic relations issue. I'm not even a lawyer and I can understand that and I can read that. And that's what I'm trying to get you all to see. I'm trying to get you all to understand, to learn how to read case law, learn how to follow rules of procedures, learn how to get some proper understanding of what's being stated in court. Don't move off of your own feelings and presumptions. Move off of what the courts are stating and how they I can't forget. I'm forgetting my term, guys. But how they interpret the law. That's what you need to find out. How these courts and these states and these agencies and these attorneys and everyone else interpreting the same law that you're trying to use against them. Once you learn how they interpret the law, then you won't go to court making these mistakes because you don't know what you're doing by just saying anything on the record. Okay? So again, guys, we're at the end of page 4 and they're cooking right now. Let's go at the top of page 5. Obtain federal court review for a purely domestic relations matter. The plaintiff attempts to use the mere mention of federal statutes without more to establish this court's jurisdiction over this domestic relation matter is insufficient as a matter of law, and as such, the court should dismiss the complaint for lack of subject matter jurisdiction. Which is true. Only thing he's doing throughout his whole complaint is quoting federal statutes, the same federal statutes that they created. So you can't use those federal statutes against those that's enforcing them against you. It just don't make sense, guys. Let's go to paragraph 2. It states, the plaintiff has not satisfied the minimum requirements for a diversity jurisdiction under subsection 1332, thus his complaint should be dismissed. The principal federal statute governing diversity jurisdiction, 28 U.S.C. subsection 1332, gives federal district courts original jurisdiction of all civil actions between citizens of different states where the amount in controversy exceeds $75,000. Case law to support that. It provides the district court shall have original jurisdiction of all civil actions where the matter in controversy exceeds the sum or value of $75,000 exclusive or interest and cause and is between citizens of different states. 28 U.S.C. subsection 1332A1, the plaintiff does not include any assertions in his complaint to establish diversity jurisdiction. If he did, such assertions would fail. The plaintiff provided an address in Nashville, Tennessee on his certificate of service, document number 1, right? Again, we went over in the first video, but let's continue. Defendant Maximus operates its business in Chattanooga, Tennessee, and Defendant Elrod resides and works in Chattanooga, Tennessee. All of the parties appear to reside in the state of Tennessee, at least when the complaint was filed and the alleged injury occurred. Then it states the court does not have diversity jurisdiction and dismissal is warranted. Then it states the court should dismiss plaintiff's claim because as discussed above, it lacks subject matter jurisdiction as required by subsection 1331 or a diversity claim pursuant to subsection 1332. Again, we're on page 5, and they rebut every presumption that he put out there, each and every one of them, using what? Legal authority, which is case law, statutes and codes, and everything else to support where they're going with this. You see? This is how you write up a legal claim. Okay? And we're on page 5, so let's pick this up at the top of page 6. B. The plaintiff fraud allegations is without merit. The plaintiff also alleges that the defendant acted fraudulently in this case, docket entry 15. However, plaintiff fails to allege any facts to support this claim. Under Tennessee law, a plaintiff asserting a fraud claim must establish the following. 1. An intentional misrepresentation with regard to a material fact. 2. Acknowledge of misrepresentation falsity, i.e. it was made knowingly or without belief in its truth, or recklessly without regard to its truth or falsity. 3. The plaintiff reasonably relied on the misrepresentation and suffered damages. And 4. The misrepresentation relates to an existing or past fact, or if the claim is based on promissory fraud, the misrepresentation must embody a promise of future actions without the present intentions to carry out the promise. Case law to support that. Let's continue, guys. Further, Federal Rules of Civil Procedure Rule B9 requires that a party alleging fraud must state with particularity the circumstances constituting fraud or mistake. Case law to support that. Allegations of fraudulent misrepresentation must be made with sufficient particularity with a sufficient factual basis to support an inference that they were knowingly made. More case law to support that. Let's continue, guys. The complaint does not state with particularity any supposed material facts that were misrepresented by defendants Maximus or Elrod. In fact, the complaint does not include any statement or misstatement by either Maximus or Elrod. Because the complaint does not plead the fraud allegations with particularity or even state credible fraud claim period, dismissal is warranted. So again, guys, we're at the end of page 6, about to start page 7, and this is how you rebut the presumptions. You go in there and you have case law and everything to support every sentence that you are quoting. That's it. That's all. This is how you write. But let's continue. C. The complaint fails to state a claim upon which relief can be granted. Federal Rules of Civil Procedures 12b-6 set the standards of review in deciding a motion to dismiss. It provides that all pleadings must contain a short and plain statement of the claim showing that the pleader is entitled to relief. See Federal Rules of Civil Procedures 8a-2. In Ashcroft, the Supreme Court held that the plaintiff must allege enough facts to make a claim plausible. Although the Federal Rules of Civil Procedures 8 does not require detailed factual allegations, the Supreme Court has made clear that plaintiff must present more than an unadored the defendant unlawfully harmed me accusations. Then it states, case law to support that. Plaintiffs that assert labels and conclusions or naked assertions devoid of further factual enhancements are not sufficient. The Supreme Court reasoned, to survive a motion to dismiss, a complaint must contain sufficient factual matters, except that it's true, to state a claim to relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inferences that the defendant is liable for the misconduct alleged. Moreover, tread-bearer recitals of the elements of a cause of action supported by mere conclusionary statements do not suffice because the court is not required to accept legal conclusions as factually true. Finally, where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct, the complaint has alleged, but is not shown that the pleader is entitled to relief. Okay, let's continue. Plaintiff constitutional violation claims against defendant are conclusionary and without merit. In this case, plaintiff made numerous conclusionary statements against all defendants. Plaintiff alleges that defendants deprived him of several rights under the United States. We're at the end of page 7, guys. Pick it up at the top of page 8. Constitution without due process. Specifically, the plaintiff made the following conclusionary statements without providing any facts to support his allegations. Voluntarily, deliberately, and with premeditation under color of non-positive 42 U.S.C. Public Health and Welfare Codes, depriving Williams of his life, liberty, and property without due process of law, and then deprived him of his inherent and indefeasible rights, privileges, and immunities secured by the Constitution and the laws. Doctrine entry 1 at 5. Then it said, did go in disguise as a state agency to on the internet superhighway under color of non-positive Title 42 U.S. codes and 45 CFR for profit with the intent to intrude upon Williams' solitude and private affairs and to subject and cause him to be subject to wage withholdings, liens on property, offset of unemployment compensation payments, seizures and sales of personal and real property, reporting to credit agencies to prevent the undeserved extension of credit, seizures of state and federal income tax refunds, revocation of various types of licenses, drivers, business, occupational, recreational, attachments of lottery winnings, and insurance settlements of debtor parents. Docket entry 1 at 7. Plaintiff further asserts that the defendant deprived him of his status as a man, his right to be free, equal, independent, due process, equal protection of the law, enjoy his life, protect his property, acquire possessions, obtain a lawyer, etc. The plaintiff, however, did not offer any facts whatsoever to support any of these claims. Remember, guys, that's what I was telling you. All his claims are conclusionary. He's just making statements and throwing them out there saying, well, they did this, they did that, they did this, they did that. But he never said how they did it. You see? And what interest did they cause him when they did that to him? Or what happened to make them do that to him? He haven't explained any of that. He's just throwing out blanket statements like I was saying in the first paragraph, in the first video. But let's continue. Specifically, as the defendant Maximus, the plaintiff alleges that Maximus is in an act of collusion, contractually deprived Williams and his right under Tennessee Constitutional Article 1, Section 18, Article 1, Section 9, Paragraph 3, the 1st, 4th, 5th, 6th, 7th, 8th, 9th, 10th, 13th, and 14th Amendment of the United States Constitution, and 42 U.S.C. Docket entry 1 and 15. Plaintiff further states that defendant Maximus held him prisoner for over 12 months, stating that Maximus is partner to defendants and held Williams prisoner for over 12 months against his will and specialized 4D coercive incarceration services, including jail, intake, enforcement, and collection that target only individuals subject to 4D activities. And now, guys, we at page 8, and you see how they addressing each point by point, explaining why the case should be dismissed. But let's continue. Let's pick this up at the top of page 9. Return for payments from CSD. However, plaintiff did not offer any facts to support these claims. All of the above references claims by plaintiff are conclusionary in nature and not supported by facts, thus do not meet the standards set forth by the court in Twombly. Then it states plaintiff allegations falls within the Supreme Court decisions of legal conclusions, where the plausibility of misconduct is present, but the complaint has not shown an entitlement to a relief. Then it's case law to support that. Let's continue. By making these conclusionary statements, the plaintiff is asking the court to accept his legal conclusions as factually true, even when some of his claims are impossible to decipher and, at best, nonsensical. For example, the plaintiff claims that Maximus held him in prison is especially without any merit because Maximus does not run an incarceration facility. It provides child support management services. It provides child support management services to TDHS. Again, guys, you see how they pointing out facts upon facts upon facts, eating that complaint alive. That complaint do not stand a chance in federal court. That's why I keep telling you, man, the person who keep telling y'all to go to these federal courts don't have a clue of what he's doing. His complaints clearly show that, and I'm just breaking them down one at a time. Let's continue. The plaintiff recognized that he does not have any actionable cause of action against defendant Elrod. Indeed, other than briefly mentioning Elrod is his introductory program, the plaintiff did not mention her name anywhere else in the complaint or state any actions that defendant Elrod may have taken to cause his injury. Therefore, the plaintiff's complaint should be dismissed for failure to state a claim upon which relief can be granted because he has failed to provide any facts to support his allegations. Again, when you're giving everybody the same boilerplate template, what do you expect? It's not going to be catered to that individual person. It's just conclusionary claims thrown out there that he's selling probably $1,500 a pop per individual to come to him, but they all receiving the same complaint, stating the same thing, and they all losing and getting the same results. That's it. That's all. Let's go to number 2. Plaintiff conspiracy claims against defendants are conclusionary and without merit. Plaintiff also attempts to raise a claim that defendant Maximus somehow conspired with the other defendants to deprive him of his rights under the Tennessee and United States Constitution. The plaintiff did not state any facts which show that the defendant had a constitutional motive in enforcing the juvenile court order subjecting his wages to garnishment. It is well settled that conspiracy claims must be pleaded with some degree of. We're at the end of page 9 now, guys. Now we're going to page 10. And this lawyer is eating his claim alive. Let's continue. Specificity and that vague and conclusionary allegations unsupported by material facts will not be sufficient to state such a claim under subsection 1983. Case law to support that. So that's why I'm telling you all, man, just start of these federal courts, man. Stop listening to these cats on YouTube lying to you all. Let's continue. Case law to support that as well. Then it states noting that a district court may dismiss a conspiracy charge in a 42 U.S.C. subsection 1983 action if the uncontested facts establish that no conspiracy existed. Therefore, the court should dismiss plaintiff claims against defendant Maximus and Elrod as a matter of law because they are conclusionary in nature and not supported by any facts, and the plaintiff failed to allege any facts with regards to his conspiracy claim. Again, guys, this lawyer is cooking over here. The lawyer knows what he's doing and he's stating his facts. So this case will be dismissed in favor of the defendants. But let's continue. 3. Defendants Maximus and Elrod are subject to quasi-judicial immunity and from a Section 1983 action because they were enforcing the juvenile court order. The Sixth Circuit has held that certain persons who act as an arm of a court is carrying out a court order are subject to quasi-judicial immunity. Okay? Again, the person who telling y'all to go to these courts known as Armando Valverde, the father of law, have not shown any evidence where the legislator waived sovereign immunity. And because he can't do that, he's going to lose every time. But let's continue. Holding that quasi-judicial immunity extends to those persons performing tasks so integral or intertwined with the judicial process that these persons are considered an arm of the judicial officer who is immune from liability. Case law to support that. Let's continue, guys. Ninth Circuit. Then it says holding that social workers who enforce a court order were subject to quasi-judicial immunity. More case law to support that. He's quoting judicial authority after judicial authority, line upon line, sentence upon sentence, precept upon precept. He is cooking. But let's continue. Holding that defendants who were acting while enforcing or executing the court order were entitled to quasi-judicial immunity because those acts are intrinsically associated with a judicial proceeding. Page 10, guys. We're on page 11. Let's finish. In determining whether a person is entitled to quasi-judicial immunity, a court will look to the nature of the functions performed and not the identity of the person who is performing it. Case law to support that. In this case, defendants Maximus and Elrod were acting in their capacity as an arm of the court when they enforced the juvenile court orders. The juvenile court ordered the defendant to pay child support per its contract with TDHS. Since the fraud law always like to dog these contract things, they're not denying that there's a contract. So you're throwing that out. It's still not rebutting the presumptions. They know that already. Like I stated at the beginning of the video, it's their statutes and codes. They created it. You can't take what they made and try to use it against them because they made it for their benefit. But let's continue. Defendant maximus is responsible for garnishing plaintiff wages in the event that the plaintiff fails to voluntarily comply with the order. Defendant Elrod is responsible for processing the paperwork to ensure that the plaintiff wages are deducted. Contrary to plaintiff assertions that the defendant fraudulently signed the child support withholding order, neither defendant Maximus nor Elrod issued the order. Defendants were simply enforcing the order as such. Both defendants Maximus and Elrod are entitled to quasi-judicial immunity and should be dismissed from this lawsuit. Conclusion. For the foregoing reasons discussed above, defendant Maximus and Elrod request the courts to dismiss the plaintiff's complaint with prejudice and assess causes against the plaintiff. So again, guys, signed by the judge, sent to all the parties. Okay? So again, guys, that's all I'm gonna do for today. Don't let nobody deceive you all talking about, oh, they're not dismissing the case because we're wrong. They're dismissing the case because all the judges work together. Okay, so let's say if that's true. Let's say everything you said is right and all the judges are working together and they all dismissing the court and they are dismissing everybody's claim because they all in some type of collusion against individuals trying to fight back. Let's just say if that's true. If that is true, then why do you still have these people going to these federal courts if you know that they're going to lose because all the courts are working together? It still don't make sense. So either the courts are working together and you're going to lose, or the courts or the attorneys have a rebuttal to all your allegations that you filed on the record and you're going to lose. So which one is it, man? You can't keep throwing these lies out here to the public and expect people to just continue to sit back and accept the lies that the fraud of law is throwing out. Now he's mad because I'm applying that pressure. See, what he failed to understand is all that joke time he was doing, see, your jokes have ran out. See, but these cases of your clients is not running out. And this information I'm providing against you and your clients is not running out. So now the joke's on you. So let's continue to apply this pressure. This is part 2, guys. Let's get this right wisdom, this right knowledge, this right understanding. Part 3 be coming up soon. That's all I'm going to do for today. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Hit that bell for notifications, okay? Let's get this ball started, man. Fight these people in the state court, start the federal court. I cannot stress this enough. But that's all I'm going to do for today. So with that being said, guys, I say Shalom.